curious to know if there's been any movement towards all virtual civil trials. And of course, I can only respond to Fulton County.
Well, yeah,
We are
everything's going to
doing-
be Fulton County, Judge.
Yeah. Let me go get another cup of coffee. So we are doing virtual voir dire, and we're obviously, Judge Brasher, Chief Judge Brasher, I'm sure can address this better than I can because he was involved in this. But every aspect of the trial is set up in a hybrid fashion in Fulton County. I don't envision moving to total virtual, but we are coordinating or implementing aspects of the trial that are handled virtually while the attorneys and the jurors are actually in the courtroom once the selection process has taken place. And I guess Judge Brasher, as Chief Judge involved in all that, I'm sure you want to address that.
Sure. Thanks, Diane. So yeah, we're excited about the utility and how well the virtual jury selection is going in Fulton County. We probably picked 25 or 30 jurors that way. I've tried 3 cases to verdict where the jury was selected virtually. It works great. The jurors love it. And honestly, the attorneys who've gone through it and tried it have enjoyed it. And so I guess I would say that nationwide, the experience of the few jurisdictions that have done virtual trials has been pretty negative. There's been a lot of concerns about external forces that come to bear, information that comes to bear on people who are not present in the courtroom during the trial. So we've kind of done the best we can with what the tools that the Supreme Court has given us, and done the virtual jury selection again, which is working well. I don't expect that we will expand beyond that, mainly because we're not going to get authority from the Supreme Court to do it. But to Judge Bessen's point, we are using a hybrid system, so we're getting lots of witnesses that are appearing virtually. We're getting evidence that's being presented to the jurors using Zoom room technology, so it's working very well.
And I might just add, I sent Brooke, I don't know if she can share screen and show those, but 2 pictures of my courtroom, because we had so many people asking, like, how's it set up? What are you doing? And so I had taken some that before each trial we send out so that folks know what it looks like. And I don't know, Brooke, if you can get a chance to do that, great. If not, I'm happy to send those to anyone that wants to see that.
I'm trying to do it right now, Judge. Oh, although I'm a host, I do not have screen sharing, so I'll try to get those up in just a minute.
Okay.
Let me just say, we're just at 12:03, so we want the questions to keep coming. Thank you, everybody, for being here. This is actually our first in this series, and we're going to do a different panel each month, and we are so thankful for our judges for being here and taking time out of their busy days. And this is exactly the type of questions that we want to ask. So thank you all for being here, because obviously access to the judges is what we all want, to ask them, pick their brains and figure out what's going on, so that when we come to court, we're more prepared and can get better outcomes for our clients. So we are so thankful to them and so thankful for you for being here. And so we can move on to the next question. It looks like there's a question for Judge Kirk. Judge Kirk, how soon will small claims and warrant application hearings be in person primarily?
And so I think Chief Judge Brasher answered that question best. We are doing those by hybrid. We will continue to do hybrid hearings at this point, as long as the numbers for COVID dictate that we have a hybrid option available, we will do that. So it is not going to be, I would say, once we get past the holiday season, hopefully maybe January, February, we will be looking at having them primarily in person. But as Judge Brasher mentioned, it has been wonderful having the option of having the hybrid hearings so that people that feel uncomfortable can do that. And so I want to thank Edie Prim for answering that. Ms. Prim is our Justice Center of Atlanta mediator. And for those of you that don't know, our small claims cases, as well as our warrant application cases, use her mediators in order to help those systems move forward. And so I want to thank you all for having me. And I want to thank Edie Prim for that question. And I obviously want to shout out Judge Ashley Drake, who's another one of the judges on the Fulton Magistrate bench. So yes, thanks y'all.
Thanks, Judge.
All right, the next question is the Atlanta Bar Family Law section had a discussion last week about educating ourselves on and overcoming our biases. What are your biases as a judge and how do you address them? And that question is sort of lobbed out to everybody. Anybody want to take that one first?
I'll go first. Well, good afternoon, and thank you to the Atlanta Bar Association and Brooke, the chair of our membership committee, for the opportunity to speak on the panel today. I'm Ashley Drake, and I'm a full-time magistrate court judge. Part of my personal creed when I became a judge was to refrain from using irrelevant facts or irrelevant issues to assess a person's credibility. And so I know that it can be frustrating when somebody is really late or somebody doesn't file a conflict letter and they're, you're waiting for them for a really long time, or during a trial if somebody does something that's extremely discourteous. But ultimately what I do is I just take a mental transition, whether that's a recess or just a moment. I take notes all the time. I'm taking notes during hearings all the time. And so I just kind of, make myself a note and make myself some space to just mentally transition so that I'm not in any way, holding some type of bias against someone for something that's really not relevant to the actual issue that I'm there to decide against them, because it's just not something that I'm supposed to consider.
Excellent, thank you. Does anybody else want to jump in?
Hi, I'm Judge Yoakum at the Juvenile Court here in Fulton. And, for me, I kind of learned this from Judge Key in South Georgia. He is a big believer in the empathetic courtroom. And I feel like that's kind of my philosophy. So if people come in and they're angry or they're disrespectful or they're rude, a lot of times I know that it's because something has happened to them. I mean, when we were back, in person, a lot of people may have had a bad experience just coming through security, and then that carries over to the courtroom. So I always try to just, level the playing field, treat everybody with respect, understand, if you're here, you're missing work, you're bringing your kids out of school. There's reasons why you might, not act appropriately. And then I try not to let that get under my skin. Also, our court a couple of years ago, we had a great class on just implicit bias. And that was very beneficial to the judges and our court staff, just to be aware that everybody has it, and you've got to, be aware of it, every time you sit down, at a hearing on the bench, and make sure that you don't bring in your own stuff when people are in front of you, or that your own buttons don't get pushed simply by what's in front of you. So that's kind of my take on that.
I could jump in. I'll say that I think that one of the tools that I've worked hardest to hone, I guess, since I've been on the bench, is just to renew my sense of empathy every time I come on the bench, just to follow along with what Judge Yoakum had said. And frankly, I'll say that my time both doing criminal as well as doing family have helped me with that. I think, we as judges come in with our own set of experiences. We all have different backgrounds. We all have experienced different things throughout our lives. And of course, the practice of law brings us a bigger variety of experiences, and then being on the bench brings an even broader variety. And I think just maintaining a sense of empathy and kind of putting that on along with the robe before you go on the bench has been one of the things that I've worked hardest at.
Thank you, judges. I think coming at what Judge Brasher said, sort of giving everyone grace. One of my partners, Eleanor Hitt, talks about that, and she reminds me of that every day. I'm a family law practitioner, for those of you who don't know. Giving everyone grace, particularly over the last 2 years, is really important right now. And I realize that's not Joanna's question, but I think that's part of what we have to do right now, is sort of give everyone a little bit of extra grace. I think Judge Yoakum said it great. It could be that someone just had a really bad time coming in, and that just sort of avalanches down. And so giving everyone that just little extra bit of grace could help. So someone asked, what is the best way to learn the custom or non-written rules of your courtroom? That's a great question because they're definitely different over everybody's courtroom. Unfortunately, they're not uniform. And so who could tell us what are the best ways to learn the rules of the courtroom for you, for instance? Who wants to start with that one?
I want to go first, Henry. We're going alphabetically.
I'll bow to you. I thought we were going age-wise.
No. And I love you for that, Henry. You're the most important person on the bench to me. This is Jane Barwick, and I'm on the Superior Court. And I do want to lift one thing up for you, and then I will yield to the smarter Judge Newkirk. But we all have web pages that can be accessed via the fultoncourt.org website. So if you go to fultoncourt.org and then press and I'll try to get maybe a shot of it up, but you go to fultoncourt.org. If everybody in the world knows this, pardon me, click judges at the top. Then there's a list that populates with all of our names and hyperlinks. And if you click each judge's name, it'll take you to, first of all, a stunning picture. And it's a picture that my brother calls I'm getting ready to sentence you to life picture. It's kind of a smarmy picture, but it's a picture. And there are also some links to standing orders in my court, in my division, continuance policies, which Judge Ellerby forced me to put on there. And then I put emergency guidelines, which are now outdated, but during the pendency of the statewide judicial emergency orders. And those, I'm stunned at who does read those, and I'm stunned at who doesn't. But I lift those up to people because certainly with regard to getting ready for jury trials and what questions I asked during voir dire and so forth. That's all. Okay, Judge Newkirk, smarter.
Jane, you and I go way back. I won't say how far back, somewhere around the 1980s, early 1980s, but
I was going to say Hammurabi's Code, but it was between Hammurabi's Code and the early 80s.
But a great way is to get to be friendly with the judge's staff. And please be mindful that the judge's staff are very frequently very close to the judge. I mean, it's like a second family after 2 or 3 decades. And the staff knows the judge, and they're happy to answer questions on a general basis. On a more informal basis, a great way to get to know the judge is through your family law section, through the GTLA, through the Georgia Defense Bar Association, and send out texts to the groups and say, hey, I got a case with Judge Newkirk. How does anyone know how he handles these particular situations? And you'll probably get an answer like, not well. But frequently, they'll give you some tips. I like to be on time. In my practice down here for the last many years, I practice in front of a bunch of Superior Court judges, and they all were different. They all started court different at different times. Some judges had reputations for being late to take the bench and early to get off the bench. And so it's good to know those things because you're trying to schedule your witnesses and the presentation of your case, and also give you a good idea of what to expect. Because in one judge who shall not be named and is deceased, he would routinely set cases for 9 o'clock, and he'd come in about 9:45, 10 o'clock. He'd take lunch for an hour and come back in 2 hours. And it used to drive me crazy as an assistant DA, trying to prepare cases. And hopefully the newest, latest and greatest generation of judges are more considerate of the attorney's time and the stress that attorneys are going through in the presentation of their cases. Let's face it, nobody comes to the courthouse without some degree of stress. Nobody comes here for a good time. And so the court needs to be cognizant of the stress that parties are under. And but more to the point, staff and your fellow litigators are probably the best source of outside of what Jane stated. And I think that what Jane does is great, putting it up, and you can see what she does, but there's always the behind the scenes. Okay, what's really going on? But I know my staff might, if you have a question, my staff would be more than happy to tell you what my procedures are. When I say take an hour lunch, it's usually right on an hour, so be timely.
I want to add, sorry, Judge Newkirk, and we are a little bit different in magistrate court. I want to encourage anybody that's interested in knowing how magistrate court works, just to simply come down. Courtrooms are open for a reason, and that is so you all can observe what it is we do. We have a website, magistratefulton.org. I would encourage you all to look at our website. You all are mainly practicing attorneys, but there are brochures on our website. There are videos that set the tone for how it is. It is truly our desire: inform, engage, empower. And that's what we want to do for our self-represented litigants, but it's also what we want to do for those parties that are practicing in our court. So I would say the easiest is to simply come and look in the court and spend a period of time. If you have that kind of time, just come and watch that judge, whichever judge will appear before. Our calendars are posted under our calendar section, Magistrate Fulton, under our calendar section. You will know what judge is sitting in what calendars, and you will get a feel for that judge. I think Judge Newkirk is correct. The judge's staff will let you know how that works, but for us, that's really going to be all of the staff. The JAs are helpful. And so my summary is come watch in person.
I'd certainly like to chime in and echo Judge Kirk's sentiments. And also on behalf of the newer judges, we're still finding our way. We came into office with a primarily virtual platform, so in-person proceedings and details have yet to be figured out, but we welcome the feedback from the practicing bar. That's how many advances in judicial practices have come from. Prime example, traffic court in their 8 o'clock calendar. Those are the things that if you suggest, new judges are certainly willing to take the best practices from many of the judges that we've received here and want to maintain an open communication with the bar that we serve.
Thank you. That's a great point. So let's talk about taking feedback, because this question is a little bit about feedback. Any suggestions on what is best to do if something has been pending for a long time without a decision? So this person says that I generally send an email inquiry to the appropriate staff person with a proposed order and very gently and politely make periodic inquiries about the status. And if this doesn't work, are there any other suggestions? What can we do to try to get this resolved?
So I'll just start first, I guess, because every judge is different. Again, how this is handled. Some judges are more current on their pending matters, some not. You have situations like a magistrate court, I'm sure Judge Kirk could address, where they're, so busy in court. Sometimes catching up on orders is not because they don't have the same staff as maybe superior or state court judges. But it is obviously touchy doesn't even begin to tell how delicate this situation is, because you don't want to, obviously don't want to jeopardize the pending motion. I will tell you that sometimes things are not, we don't know they're pending. So most of the time we do, it's an electronic system in Fulton, but there are times when something slips through. And so it's not that we didn't mean to answer, we just didn't know it was pending. So I don't think, and the other judges can pipe in a minute, I don't think you're ever at fault, as was sort of suggested in the question, to contact either a staff attorney or the JA in Fulton and say, I'm just curious, I've had this pending. Now, obviously, if you just filed a motion for summary judgment and it's been 2 days, please don't call. I mean, we're good, but give us a minute. But if it's something that has been pending for more than, I would say, I don't know, maybe more than 4 months or 4 to 6 months. And again, every judge's calendars and process is different, but beyond 6 months, maybe it's not on someone's radar. And I think it's certainly appropriate to say, just want to make sure you're aware of this. Do I need to send an actual hard copy of the pending motion? Beyond that, if you do that and then don't get any sort of resolution, I'll just be honest, I don't know what you can do. It is a terrible situation to be in. I have sort of people in the public who have pending matters ask me, they don't know what to do. Obviously I can't really respond other than say, talk to your attorney, but it can be very delicate. And I don't know beyond that what's appropriate or not. And people with more experience than me might want to address that.
Well, I think the chief judge is the next go-to person, frankly, and after a substantial period of time, contact the chief judge. And obviously, none of us want to have a bar complaint or bench complaint lodged against us for not being timely and producing our work. But be cognizant that when you file something, we don't get an email saying, "Hey, Brooke French just filed this motion for summary judgment. So please send an email or a notice to the staff attorney saying, just heads up, I filed a motion for summary judgment in the XYZ case this afternoon." Put it on our staff's radar. We've had a couple recent incidents where a motion for summary judgment was filed and we had no idea that is out there. We've got over 600 cases, and just because it's filed, that doesn't mean we get notice by the clerk's office that it's there. So shoot us a text, or not a text, but an email to the staff attorney indicating that it's been filed, and we'll pull it out and take a look at it and put it on our radar.
I'll echo what Henry said. I think the cases that don't get responded to fall into two categories. The first is those that have been overlooked. And that's kind of the point that Henry made, that just because something gets filed doesn't mean we know about it. We don't get any emails or notifications when things are filed into Odyssey. So, check with the judge, but many judges want courtesy copies just so we know that they've been filed. The other category that I think this question is more aimed at are those that have been neglected. And matters that are neglected, the way that I used to approach it when I was in practice would be the contacting the staff attorney. Does the judge have everything she needs to address this? Is there something else that I can do? And if that goes unresponded to, then a call to the chief judge. And look, I've gotten a number of those calls since I've been in this position. And my way of handling it is that I will reach out to the judge at issue, and I will not say which party it was that requested it. Depending on what kind of motion it is, it's probably not hard to figure out, but I'll say, I had an inquiry regarding a pending matter in this case. You may want to take a look at it. That's how I'm going to approach it, so that the judge will hear in a collegial way that something is going on there. And interestingly, of the dozen or so that I've gotten over the past 2 years, I've never gotten a second inquiry about the same case. So I'm not saying that they all were resolved appropriately, but certainly most of them were. So I welcome that. I'll tell you the other two paths that probably are not going to get you, not going to win friends and influence people, are filing JQC complaints and filing mandamus actions against the judge. Because the reality is what you're probably going to end up with is a recusal and a problem. So there is that tool out there, the mandamus tool, but it is, as with most things like that, a very blunt instrument. So don't be afraid to call the chief judge or email the chief judge's staff and see if you can't get some help that way.
Specifically in Fulton County Magistrate Court, as it relates to garnishments, I can tell you that the way that the garnishment work is, when you file a motion, that motion will go to the presiding judge, who will then send it to me as the garnishment judge to consider. And so if it's not coded in Odyssey as a motion, so if it's coded as maybe a certificate, or if it's coded as a letter, if it's not coded as a motion, it usually 99.9% of the time isn't going to make its way to a judge for consideration. There are the few times when it just gets missed, and I don't know why it gets missed. I've asked why it gets missed. I'm not sure why it does, but we do have 2 or 3 different things that I just wanted to let you know about. I'm very current on the garnishment queue, and so if you file something today, I'm going to make a decision within 7 days. And the only exception to that is if I'm on vacation or something like that. But if you 60 to 90 days have gone by and you don't have an answer on a garnishment case, then I definitely want someone to reach out to my office. And the best ways to do that is we have a really great website, magistratefulton.org, and that's magistratefulton.org. Or you can, and when you go there, we have a chat bot. Our customer service email address is on there. It's customerservice.magistrate@fultoncountyga.gov. And I would ask that you not send a proposed order, just give a heads up. If you have a proposed order, it should be filed into the case. And for me personally, but that's my one thing. But just giving me a heads up that something's been waiting, I don't see any problem with that, and I actually prefer it. Thank you.
And so just to jump back on that, remember that in magistrate court, there are 2 staff attorneys for 30 judges. So it's not like you are speaking to a state or superior court judge who has their own assigned individual staff. That's not the way it works in magistrate court court. So when those cases are filed in, they actually go into a queue. And Judge Drake mentioned that the presiding judge goes into the presiding judge's queue and then filters items elsewhere that don't get immediately placed there. So it is very possible that the item you are attempting to track has gone somewhere else. Magistrate JA request is an email at fultoncountyga.gov, is the best email to figure out where it is and what it is. If you look at our order of business, there is actually a magistrate email address that is assigned to whatever case type you are attempting to track. There is a JA that will assist you from there. And so that is probably the best. Judge Drake does garnishments, and as she said, is doing a wonderful job there. Those are current. And so garnishments, absolutely Judge Drake, but everyone else, the magistrate.ja request at fultoncountyga.gov is the best way to track down what's happening.
So to follow up on that, how does the court learn about motions and things that are filed?
So the way that we in our division do is that my staff attorney walks the docket usually every 2 to 3 weeks to see what's been filed. And the reality is that there are, Henry said 600 cases. It's not unusual for judges between criminal and civil to have somewhere between 400 and 800 cases. And there's really, there is no mechanism for us to know when something is filed that is useful, because we can tick a box on cases so that we get notified when something is filed in every case, and then it becomes, we get 150 to 200 emails a day, and that's not useful either. So the reality is that if folks don't send courtesy copies, and some judges want them, when I used to practice federal court, we'd get a Rule 11 sanction against you if you sent courtesy copies to them. So don't do that if you're not supposed to. But most judges appreciate them, at least by email, the courtesy copy. But as I said, my staff attorney is walking the docket usually two to three times a month.
Thank you. That's helpful. This is a little outside the scope, but I think a lot of people on here might be interested. If you were interested, or if someone on the panel could explain what their path was to becoming a judge, and if someone here who's an attendee is interested in becoming a judge, are there certain things that are do's and don'ts for becoming a judge? Or what are some things, the top 2 or 3 things you'd say, oh, well, you should do this or you shouldn't do this on your path to becoming a judge? Does anybody have something they'd like to share on that. Maybe Judge Ward, we haven't heard from you. I'd love to hear your thoughts on that.
Yes, thank you for having me, Ms. French. This is Christopher Ward, Deputy Chief Judge, Municipal Court of Atlanta. I'd like to state that if you have any information or any need for any information from the court, the information is right before you. We have a comprehensive website. You can research your case. You can inquire about the status of your case. You can even pay the fine prior to your court date, depending upon the offense. Court.atlantagA.gov at 404-658-6940. So, to get to the question, I started my career with the desire to become a judge. Throughout my career, I served as a public defender, assistant district attorney, corporate attorney, had the opportunity to serve as juvenile court judge on a pro bono basis prior to being appointed here at the Municipal Court of Atlanta. You know, I had a defined path. I knew where I wanted to be. I know where I want to be. That was a joke. But in that regard, you know, I would say that if you would like to serve as a judge, try to get as much experience as possible. I've sat in every area of the courtroom other than the bailiff and the court reporter. Prosecutor, defense attorney, corporate attorney, civil practice, in an effort to fulfill my goal. You need to know where you want to go, what you need to do to get there, and speak to other folk about their path. And you know, you will get some information, some advice that would, you know, pretty much help you in that regard. But follow your dreams in that regard, and that's what I have to offer.
Brooke, from a nuts and bolts standpoint, you have to work hard and have a good reputation with the bar. And you need a lot of luck, and you need to sit down and really figure out who your friends are and who your friends are friends with. It's better if your friends know the people that need to be spoken to than to have a friend who knows a friend who knows a friend who knows the head of the committee. So a lot of people go through their practice and sometimes just don't realize how many contacts that they've made. And if you sit down and think about it and think that, you know, this defense lawyer that I had a trial case with 2 years ago went to college with somebody who's on the committee, and they have a relationship, and the person has a reputation for hard work and doing a good job, and people are willing to go to bat for you. But you do have to go through the process of getting through the committee, and regardless of who's in office, it's sometimes has political leanings with the governor or the mayor or whoever the appointing officer is. But
So,
usually everybody who applies is pretty much qualified. You know, they've done a good job in law. They're smart and worked hard, and you have to interview well, but you have to get your foot in the door. And sometimes it's a matter of getting contact with people to put your name on the radar.
so let me say, other than Judge Johnson and Judge Barwick, everyone else seated here, the secret we don't say out loud is we knew someone. That's the bottom line. And I never even wanted to go to law school. So how I'm here, I'm really not sure. And I'm not going to go into that story right now. But I literally became a judge because my husband knew someone. And I'm not embarrassed to say that. I mean, my first magistrate position, because he knew Judge Carnes, and they were looking for part-time magistrates. And I'm not saying that's fair or that's right, but other than running like Judge Barwick and Judge Johnson did, and I'm sure they should probably chime in just a minute, because that's how they got their spot. The rest of us, it's not to say the things that Judge Newkirk just said and Judge Ward are not true, but the reality is you can be all those things. And if you don't have a connection, it doesn't mean you'll never get here, but it is extremely difficult. And these are political appointments. They are, we say they're political throwaways. We don't think of it that way. And we like to think each of us that was appointed certainly deserved it. But I can't emphasize more than, and it's not the way it should be, but you have to understand that that is an important component.
I'd like to add that basically you have to keep your goal in mind. Before being appointed to my first judgeship, I applied 5 separate times. And, you have to understand, piggybacking on what Judge Newkirk stated, you have to recognize your visibility. Get involved in bar associations, become active and contributing members. Understand that every time you walk in the courtroom, someone is looking at you. And, 2-3 years down the line, they're going to remember that. And it's just basically a matter of being utmost and the epitome of professionalism. Treat people like you want to be treated. Your reputation is all you have in this business. And sometimes that's not good enough. But continue to work and do what you need to do to achieve your goal. Don't stop. It's not fair. And some get it, others get it faster than others. But this is a noble profession. We serve others, and if that's your heart, continue to, follow your dreams, and it'll happen.
Thank you, Judge Ward. I'd like to piggyback off of what has been said. I chose to run for an open seat, and I had 3 opponents. I won that race outright without a runoff, and I didn't expect that I would be appointed. To be appointed, you have to impress a handful of the right people. But to seek election from the public, I had to impress a large group of people. And so I, in my platform, always took it back to the voters and to the community. And in the role, if you want to be a judge and you're not in position to be appointed, then you take your message to the people. And that's why my work in this court, as well as my messaging on the campaign, will always speak to the people that I serve. And I think that was the key to success if you choose to mount a campaign. So there's more than one way to skin a cat.
I think all of these, sorry, go ahead, Judge.
No, I was just going to say, there you have it. Judge Johnson's right. There's 2 paths, and you just got to figure out what's best for you and what you think you can do at a particular period in time.
Now, I was just going to piggyback on kind of what Judge Newkirk said in terms of just relationships. I mean, I think they are so important in terms of getting here. I know there was someone that was involved in appointing me that I did not know, but it happened to be that one of this person's best friend who went to church with this person used to work for me. So we had a good relationship, 10 years ago when I was this person's supervisor, and she happened to be very good friends with someone who was involved with appointing me. So I think it's cumulative over the years. If you have a good reputation, if you work well with people, if you treat people with respect, all of that kind of comes back around. And to me, this is kind of a small community, and people know you, they know who you are, they know people that you know. And I think, like I said, that relationships are very important in answering that question.
Well, in relationships in general, I think regardless of what your path is, whether you're going to just continue to be a lawyer, not that that's not enough, but whether you're going to continue to be a lawyer or whether you're going to seek an office or something like that, those relationships are important. And I can't remember which judge said it, but your reputation is very important, and making sure that we show kindness to everyone, whether it's opposing counsel or an opposing party or our client or staff or staff for the judge or whomever it is. Particularly during the past couple of years, I think it's been really important for us to do that, and it just shows how y'all have done it. Obviously, you've all done it in 9 different ways. There are 9 of you on the panel today. You've all done it in 9 different ways and gotten someplace that you wanted to be. And it just shows that there are obviously, as we said, different ways to skin a cat. Speaking of that, I have a question, and this is obviously from someone who does criminal law, because I don't understand the question, so forgive me. But this is to Judge Kirk and Newkirk and Barwick and Judge Brasher. It would be great if there was a centralized way or centralized person to contact to get a hearing on an unindicted case. For example, a motion to modify a bond. As you may or may not be aware, we file motions and they go into oblivion. So I'm not sure if that's a question or just a comment. Since I don't do criminal law, I'm not really sure. But that was a statement that I received. So I'm not sure if that's a question that you can answer, maybe, Judge Brasher?
Sure. I'd be glad to take a stab at it. I think the reality is that the pandemic has brought into sharp relief the difficulty that happens when you have a long span of time between when someone is arrested and in which a formal charge is or is not preferred against them, either by indictment or accusation. And so we have a lot of people who have been arrested, have gotten a bond, their cases have not been indicted yet, and even some who did not get a bond and haven't been indicted yet because of the delay in the 90-day indict or release requirement. And so the reality is that if the place where it's supposed to go is the court in which it resides. And I say that because ultimately, until a case is indicted, we as Superior Court judges don't have jurisdiction over it, except insofar as the code requires. And the code requires for bonds, because only Superior Court judges can hear bonds on certain kinds of cases. And so it is caught in that limbo between the judges who handle it as a procedural constitutional matter, that is the magistrates who do first appearance, et cetera, and the judges who will ultimately preside over it once it's indicted. And so, I'm not going to definitively say that these are magistrate court cases, because they're not, and I'm not going to definitively say that they're Superior Court cases, because they're not. That being said, we are constantly trying to get unindicted cases moving. And we recognize that there is a significant lag in getting cases indicted. So you can contact the court administrator's office, you can contact my office, I'm sure you can contact Judge Kirk's office, and somebody among us will find a place for these cases to be heard, because we want them to, but there is no natural home for them because of that differential between when those constitutional requirements are fulfilled and when the case is actually assigned to a courtroom when it is indicted. Judge Kirk, I certainly wasn't trying to throw you or your court under the bus on that at all.
Not at all. And it appears, and thankfully the attorney is Attorney Pines, who has been in the Fulton County system for a very long time. And I am comfortable telling him, as well as any of the other people that are attempting to get a hearing in an unindicted case, if it is unindicted, Lynette Ross is going to be the best person to contact. I have placed her email in the chat, so I would encourage you to use that. Ms. Ross is the person from Superior Court that kind of helps manage where all of those cases go as they are unindicted. She is the person primarily responsible for the non-complex division. So from the preliminary hearing, bond hearing to NC1 and NC2, and Noah knows what I mean, but that is the person that is going to be able to help you. I will also tell you that Judges McBurney and Ingram Millender are always revising how that scheduling works. And so Judges Borski and DeFore, sorry y'all, and Brooks, who are sitting those calendars, are also creating waiting lists. So if there are cases that they can put on waiting lists to be able to pull them off when calendars fall through, Ms. Ross is the person to help you get them there. So I hope that helps.
I also believe that DA Fonnie Willis is doing a very admirable job in trying to get these cases moving. She walked into a tidal wave of backup cases. So buckle your seatbelts, because the tidal wave is getting ready to hit courts and everything else. But I think the criminal courts are going to be real busy for the next couple of years. And the court is trying to get ready for it by hiring additional senior judges to handle cases. And the details are with Judge Brasher, because I'm out of criminal now. But I know that an awful lot is going on to try to get us back to where we were 2 years ago. It's not going to happen in 2 years.
Speaking of the backlog, Judge Newkirk, I appreciate you sort of bringing that up. It seems like there is quite a backlog, and understandably so. Is there now an emphasis in the court, state superior court? I don't know if they do this in magistrate or municipal or juvenile court or probate court, but is there an emphasis in the court now to try to utilize special masters and arbitration because there's such a backlog, because it seems like their cases are getting referred to that now, which they haven't been for quite some time. Is that something that y'all see as something that's here and going to be utilized more? Or is that just trying to push through the backlog?
So I'll jump in and say that when we talk about a backlog, there's really two components to it. There are the cases that existed when COVID started that have been delayed because of that, because of COVID and the statewide judicial emergency. And then there are the unindicted criminal cases that Judge Newkirk was alluding to when he talked about tidal waves. And those two things are in tension with each other, and it's because there is, to some degree, a zero-sum equation on that. So our goal has been that we're trying to expand the process, and I'll let you in on a little secret. We had conversations about a year ago. We were talking about how to do this, and the joke was made, well, I think we need a bigger boat in order to make this work. And out of that joke came the Project Orca, which is, if you're a fan of Jaws, where that line comes from. And so Fulton County has invested $75 million of ARPA funds, American Rescue Plan Act funds, in the court system. It's not just Superior Court, it's all the constituent agencies within the court system are getting sums of money to help expand their process. So it's not to buy extra equipment and things like that. It's to build out additional capacity. Our goal was to increase the capacity of the court system, not just criminal, but family and civil as well, by 25%, using additional staff, additional prosecutors, additional public defenders, additional sheriff's deputies, court administration folks, litigation managers, et cetera, staff attorneys, and senior judges to increase the capacity of the court system. The idea was that we can handle this deluge of cases in this way without having to make an either or choice. And so, for instance, one of the reasons why we're doing virtual voir dire is because if we didn't start that in April like we did, we might not be trying civil cases yet. We may only be trying criminal cases, but we are trying civil cases, and we're seeing civil cases move along. I know that even in the family division, they're able to use the virtual voir dire as well. But we are going to continue to use senior judges. There will continue to be, as there has been since the beginning of the pandemic, a focus on trying to handle things through alternate dispute resolution as much as possible. I'll tell you, we've had some discussions about special masters. Special masters are difficult because they're expensive. And we've got the limited use of special masters on the Uniform Superior Court rule. Then there are other statutory proceedings that require special masters. But under the Uniform Superior Court rule, you can end up sometimes making a process more difficult because of the ability to object and all the other things that happen, and questions about fees and division of them. So those are great for people who self-select into that process, but it's very difficult for the court to effectively make people do that. And I think that's why the Uniform Superior Court rule was written the way it is, so that it would have that reticence to it. So all of those things are on the table, but rest assured that the focus of the court system is to expand its process so that all these things can move through, not just criminal. That being said, there is a constitutional mandate on handling criminal cases that doesn't exist in the civil cases. So we will have a lot to deal with, and we're trying to deal with as many of the other cases now as we can, so that when that expected wave of cases comes, we won't be freezing out all of the family and civil cases. That's my take. I hope I answered the question.
And there's a little different, in state court where we do have a backlog of criminal cases, not nearly as big as in Superior Court. That's just, there aren't as many misdemeanors, but probably fortunately or unfortunately, but just to let you know too, in Fulton County, we get our case numbers, at least state court, we get them monthly. I'm assuming in Superior Court, that's true. So we do know exactly what we've got outstanding. In our situation, once we're now able to get the criminal cases on calendars, even though there's somewhat of a backlog, we expect those cases to resolve pretty quickly, because most of those don't have the kind of consequences you have with felony cases that absolutely need to be tried. I mean, if the offer's 30 years, you have no choice but to try it. We don't have that same situation in state court. We do have I wouldn't say it's a backlog of civil cases. Our numbers are not out of line with what they were 2-3 years ago, but we have a lot of cases that are going to require trials. And I know most of the judges in the state court have been continually through the pandemic having status conferences. If you've been to mediation once, and it was a year ago, we try and send you again. But there are a lot of cases that I just sort of run-of-the-mill car accident cases. I mean, I've tried 4 or 5 in the last 6 weeks or 7 weeks. I know I just am going to have a number of those that I have to keep trying. We have not been able to yet get to the bigger sort of med mal cases, products cases, wrongful death, because our jury numbers didn't permit us to bring down 60 or 75 jurors. We've reserved those for criminal, but we are starting now and into the beginning of next year. So I think you'll see some of those larger cases actually end up on calendars. And a lot of those just have to be tried because of the dollar amounts and the possible ramifications.
Well, thank you for that explanation. And we know that y'all have been just working so hard for the past nearly 2 years to try to keep things moving and avoid the backlog. And we appreciate that so much, not only as advocates, but also some as litigants, and our clients certainly appreciate that as well. We have reached the end of our 45-minute time slot, so I apologize for running over a little bit. I'm sure no one minds that we bent your ear for a little bit longer than that. So on behalf of the Atlanta Bar Association, we appreciate everyone for attending, and we certainly appreciate the judges. Judges, if you mind hanging on for just a few minutes so that we can let everyone go, and then we're going to just wrap up. But thank you everyone for attending. We have another one of these next month with DeKalb County. So thank you on behalf of the Bar Association for attending, and judges, thank you for being here. So we appreciate you, and appreciate everyone for being here. Thank you. Thank you, judges.
Thank you.
Thanks for having us.
Of course, you're welcome.
Thank you.
You're welcome. Yeah, we just want to grab a picture of everyone for us to put into the Atlanta Bar for Judge Bessen and the Atlanta Lawyer Magazine.
Atlanta Lawyer Magazine. We definitely need that.
Yes. I don't know if Harry stayed on.
If you would like.
I don't know if Harry stayed on.
Oh,
he might have
Harry,
left.
he's gone? He had
I
a
don't know.
question. He had a fun question too, but I know it's hard to answer everything.
By the way, I learned so much hearing from everyone. It's been an honor just to hear from you all. We should do this more as a judicial section in a way. I've enjoyed it.
I agree.
Yeah, it's so interesting to hear from different parts, because I mean, I only practice in superior courts, and frankly, Fulton just has this family law. So I only see, 3-4 judges, and then I don't see anybody else. And so it's really interesting to hear from what everybody else does, and how things work. It's just so different, how everybody does everything. It's really interesting to hear all of that. And just, I didn't realize, Judge Brasher, when you said, we don't get notice of everything that's filed, I was like, oh, right. Of course you don't. Why would you? Because then you would get hundreds of emails every day of all these things. And
No.
Thousands.
Brooke, we
Thousands.
would get
Thousands.
hundreds more emails than
Right,
hundreds that we
sorry.
already get.
And let's not forget, some of us on the screen have been here long enough to remember, we had paper files. So,
oh,
we've really made tremendous strides, and now we have obviously higher expectations, attorneys do, because of it. So, which is good, I guess.
I remember.
You certainly don't have nearly as many things that fall through the cracks, because you can know at any given time what cases are on your docket. You can, and you can know it basically within hours of it being filed. It's just the practical matter of how that gets to your attention. And, different judges do it different ways. Some keep the little boxes ticked and get all those emails. I just can't. I have a hard time seeing all the emails I get in a day as it is now, much less doing it that way. So again, I think courtesy copy is a great way to do it.
Actually.
Brooke,
Thanks for
thank you very
having
much.
us.
Thank you.
All right. Well,
you,
thank you
again.
so much. I appreciate all of you immensely.
Thanks, Brooke. Good to see you. Take care.
You
Good to
too,
see
y'all.
everybody.
Thank you
Y'all have a
so
good evening.
much.
Bye, Judge
Thank you.
Kirk.
Thank you.
Bye,
Thank
everyone.
you.
Thanks, y'all.